evidence in this case, it now becomes your duty to render a verdict to determine whether or not the state of Texas proved their case to you beyond a reasonable doubt. This is the jury charge. You get to take it back in the jury room with you. This is the law as provided to you by the court. You are the facts of the evidence, and you get to determine whether or not the state proved their case beyond a reasonable doubt. Page 2 of the jury charge, and it's not numbered. I'm not sure why they don't number jury charges, but I've numbered mine. You have to decide if Mr. Elliott intentionally or knowingly caused the death of Meghan. It has to be his conscious objective, and he had to be aware of what he was doing for you to find him guilty of murder. And I submit to you that the state has not proven that. This charge also tells you that you can consider the previous relationship existing between the accused and the deceased. And that relationship was nothing but good. As the state has told you, there's no reason. Actually, what Mr. Katani said was, you don't have to know the reason or the motive, but it's hard to know a reason or a motive if there simply is not one. And in this case, there is not one. If you go on in the charge to page 5, the prosecution has the burden of proving the defendant guilty, and it must do so by providing each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. Not you may or you should, but you must acquit the defendant. So when you go back in the jury room, you have to determine the guilt or innocence of Mr. Elliott. I'm going to start by responding to something Mr. Katani showed you. They're really hung up on this alphanumeric passcode on his phone. That he had to enter in all these letters. But as you can see on this form, what he means by alphanumeric is he chose the words he wanted to have his password be, but his password is all numbers. It's not letters. He's not typing in letters. He's typing in the password. He's typing in these numbers, not those letters. Those letters equate to these numbers. This is his password to the phone. That's how he got into the phone. That or the thumbprint. The job of the assistant district attorney is to seek justice. That is their job. Have they done that in this case? It is not to get a conviction. But in this case, that is what they are trying to do, not seek justice. They have put forth claims, speculation about what happened that night. Oh, he must have been sleeping because he wasn't on his phone for 6 hours. And Mr. Rucker and I have disproven what they have tried to sell you, their narrative of what happened. We don't have a burden. We don't have to put forth anything. But in this case, who is putting forth the evidence to show you what really happened? It is not the state of Texas. It is not them. Mr. Elliott got arrested or detained on September 29th of 2021 around 5 in the morning. They leave him sitting in a patrol car for hours. They drive him downtown to the Sheriff's Department Homicide Division on Lockwood, which probably took about an hour. And then they interviewed him. And Deputy Munoz told you before the interview, he listened to the 911 call. He knew that Mr. Elliott had admitted to stabbing his sister. He interviews him. He arrests him. He charges him with murder, and he takes him to jail. And as far as he's concerned, his job is done. He's got the person who committed the conduct, who caused the death. End of story. The Harris County District Attorney's Office, the same. believe that this sleepwalking defense, they had no idea about it. I mean, Kathy Elliott, my client's mother, was asked, well, I mean, how would we know to investigate this sleepwalking if we didn't know it existed? But I submit to you that when my client was charged with murder on September 29th of 2021, they had a really good idea because he says he's dreaming. Dr. Simmons' report was dated May 30th of 2022. At that point, you would think they would know that the defense is sleepwalking. They get him indicted for murder on April 24th of 2023 before they ever get Dr. Pressman's report on May 6th of 2023. And why is that important? Because Dr. Pressman had Dr. Simmons' report prior to writing his report. Dr. Pressman is very proud to be an expert witness. That's what he does. He testifies in these cases. That's his job. Very, very, very proud of that. He had Dr. Simmons' report. He knew Dr. Simmons had seen Ben, my client. He knew Dr. Simmons had done not one, but 2 polysomnographs. He didn't ask for those reports. He didn't ask for the raw data. What did he review? What the state gave him to prove their narrative. The offense report, the 911 call, everything they wanted him to have to come down on their side. He says in his book, and he says on his website, if you're going to testify for the state, you should ask to speak to the defendant and anybody else that might have pertinent information. It's written in his book. It's written on his website. It's so important. You should make the request in writing, and you should get the rejection in writing. And does he do that in this case? Doesn't follow his own advice, and no, he does not. So he renders an opinion about whether or not my client was suffering from a parasomnia when this happened with half the evidence. Because he doesn't care what our evidence shows. Because he's going to come down on the side of the state. Let's talk about the parasomnias. I believe we can all agree that they're real. Both Dr. Pressman and Dr. Simmons agree to that. There are violent parasomnias. Thankfully, they don't occur very often. Dr. Simmons testified that they're all different. They're different from person to person. They're different from night to night. They are not all the same. They happen generally in slow wave sleep, which is the 3rd stage of sleep. But they can happen in stage 2. Generally, it takes a person 30, 20, 40 minutes to get in this stage of sleep, but not always. Their own expert testified in the United Kingdom in that case that that defendant got to that state of sleep in 5 to 7 minutes. The state is really proud of this slide because it's their position that this was not enough time for our client to be in that state of sleep. But Dr. Simmons' polysomnographs proves that he could have been. I submit to you that he was likely falling asleep before this, putting his phone down, picking it up, looking at the time, like Dr. Simmons described with the remote. Sometimes you fall asleep, you wake back up. So there was plenty of time for him to be asleep. Dr. Pressman testifies in cases where the parasomnia fits into his box. If it doesn't fit into his box, then he does not believe it was a parasomnia. He references his sleep study, a sleep article that he did from 2007, where there were only 32 subjects. And he agreed with me that there were 5 or 6 that did not fit in the box. These were Dr. Pressman's conclusions. This is how I wrote them down. If you remember them differently, I'm not going to argue about that. You might remember them differently than I do. Dr. Pressman's position is that during a parasomnia, you would have no memory of the event. But the literature says otherwise. You can have pockets of memory, which does not mean that you're conscious. Because during a parasomnia, part of your brain is trying to stay asleep, part of your brain is trying to stay awake, and you're not in a wakeful state, you are not conscious of what's going on. But you can have some memory. Dr. Pressman testified about memories that my client had that there's absolutely no testimony of. He testified that he remembered.
Cary Hart delivering the close for the defense. We'll get a break. We'll get you back into the courtroom for more right after this. Stay with us.
In today.
Welcome back to Court TV Live. We are in Texas, Houston, Texas. We've been watching the closing arguments in the Sleepwalking twin murder trial. The defendant here, Benjamin Elliott. He is charged with felony murder after prosecutors say he intentionally stabbed his twin sister to death. Elliott and his defense team claims he was sleepwalking and woke up, and he had a great relationship with his twin sister. He was in a dream. He found himself standing over his sister. She had a knife in her neck. Let's go back into the courtroom now. We're watching the defense closing argument.
Sheath, but there's zero testimony that my client has ever said that. He doesn't remember getting the knife out of the sheath. He doesn't remember getting out of bed. He doesn't remember going to Meghan Elliott's room. He doesn't remember stabbing her the first time. He doesn't come to until he's stabbed her the second time. They want you to believe that he went to her room to kill her. You could tell from his interview that he cannot see without his glasses. And when he goes to her room, he does not have his glasses on. Because he was sleepwalking, not because he went there to kill her. And again, the state and their narrative. They go to the house a week before trial. They're not contacting anyone who has information about parasomnias that my client has suffered previously. I mean, Kathy Elliott told you, she told Josh Rager, the first DA she ever spoke to, the only DA she ever spoke to, about Anon and what he had told them about Ben's parasomnias. They don't even bother to call and follow up on that. But he does not remember the events leading up to the second stab wound. Dr. Pressman believes he came to too fast. That you have evidence before you that Dr. Simmons thought was very important about that sleepwalking event with the donut because he reoriented quickly. And I submit to you that when you hear someone that you love struggling, you could come to pretty quickly. And again, no one was there. We don't really know how quickly he oriented, but what we do know is that when he did everything he could to save his sister. Dr. Pressman says there's no evidence of provocation. But again, we don't know that because we were not there and no one else was, and there's no one here to tell us. Dr. Simmons testified that the provocation could be as little as just touching someone to cause them to do this. And then Dr. Pressman commented about Meghan Elliott laying on her side. I don't know where he got that information. That's the first time I've ever heard that. Dr. Pressman is stuck back in 2007. As you heard, there are a lot of articles written about sleepwalking and parasomnias every year. Dr. Simmons looked at an article that was written last year, which is a lot more current than 2007. And that article was written by Shank, who is a sleep expert, who also wrote the chapter on parasomnias in the International Classification of Sleep Disorders, a well-respected individual, and these are the 6 things that they believe someone who's going to testify at trial in one of these cases should look at. Does the accused have a sleep diagnosis? In this case, Mr. Elliott has prior instances of sleepwalking, prior instances of disorders of arousal where he's wrapping the sheet around his head. He has family members who have sleep issues. Short duration. Definitely we believe it was a short duration, especially if you believe the state's timeline. We don't know how long it was, but it certainly was not a long duration. Lack of motive. The state does not have to prove motive to you, but you can look at a lack of motive to determine whether or not someone was suffering from a parasomnia, which in this case, Mr. Elliott was. Okay, proximity to the weapon and to the victim. Clearly, Ben was close to the weapon. It was right by his bed. As you've heard, the Elliott family, and as you've seen, they use knives a lot. It's not unusual for knives to be around. In fact, on Mr. Elliott's bedside table, or what was next to his bed, there were still 3 knives there. Knives are something they use all the time. Proximity to the victim. He was 9 feet, I believe, is what the state measured. And again, their measurements, they measured what was convenient for them. They measured from Mr. Elliott's room to the bathroom, and Mr. Elliott's room to his sister's room. They didn't bother measuring to the front door or to the kitchen or anywhere else to see if maybe that's where he might have gone. They only measured what fit their narrative, which is what they have done this entire case, is put forth what fits their narrative. And that's it. As we know from the testimony of Dr. Simmons, proximity is not, you can't exclude that it was a parasomnia based solely on that, as we know from the case of Mr. Parks. I mean, he got up, got dressed, got in his car, and drove to his in-laws' house. So it doesn't have to be, as Pressman would like it, to fit into a neat little box. These don't happen that way. No attempt to cover it up. I think the state said at some point, he was trying to cover it up because he was whispering to 911. But I would submit to you, if you're trying to cover something up, you're not calling 911. You're not begging for someone to help your sister. Amnesia or dreams. Mr. Elliott does have amnesia up until the second stab wound. Never does he say his sister is stabbed twice, because he simply does not remember. Dreams. It's not uncommon for people to wake up, not know what's going on, and to remember it as a dream. And Dr. Simmons testified that in this stage of sleep, you can have dream-like quality, things that are like a dream, but they're not vivid like you would have in REM sleep. So you can have some little islands of memory while you're dreaming. It does not mean you're conscious. After looking at all of the evidence and deliberating, and the other thing I was going to tell you, a lot of jurors, when they get back in the jury room, want to see items. You're allowed to see anything that was admitted into evidence.
You're at 20 minutes.
Thank you, Judge. You're allowed to see anything that was admitted into evidence for your consideration. Those things you can get in the jury room. You can get the 911, the body cams, those sorts of things. But some things are not admissible under the law. So like you can't ask for the offense report. If you ask for a transcript of the trial, that would not be given to you. But you can see items of evidence. And I submit to you that in this case, the state has the burden of proof beyond a reasonable doubt, and they have not met that burden. I'm asking you to find my client not guilty.